Court of Appeal in and for the 5th District of the State of Florida is now in session. The Honorable William D. Palmer, Judge presiding. All persons having business before this court draw near, lend an ear, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
Good morning and welcome to an oral argument session of the 5th District Court of Appeal. Let me begin by introducing the panel. As you've already heard, I'm Judge Palmer. To my right is Judge Orfinger. To my left, we're happy to have an associate judge with us, Judge Lisa Munyon from the Ninth Circuit. We have both criminal and civil cases on the docket today, 15 minutes per side on the criminal case, 20 minutes per side on the civil case. The appellant can reserve as much time for rebuttal as they choose. If you have cell phones, please make sure they're silenced before we start. First case is APPERSON versus State.
Good morning, Your Honors. May it please the Court, my name is William Pinnell and I represent Matthew Apperson, the appellant in this case. Please reserve 4 minutes of my time for rebuttal.
All right, when the yellow light comes on, you'll be into your rebuttal time.
Thank you, Judge. Based on the various errors in the self-defense jury instructions and several improper arguments by the prosecutor during closing argument, it's impossible for this court to have confidence in the outcome of Mr. Apperson's trial, and as a result, this court should reverse his convictions and remand for a new trial on all 3 counts of conviction. Initially, the first error and all these instructions are raised as ineffective assistance of trial counsel because trial counsel did provide these instructions to the judge, and those instructions were provided, but there's no reasonable strategic or tactical reason to provide instructions that would have hurt Mr. Apperson's claim of self-defense in this case. The first error was the instruction on self-defense incorrectly indicated that Mr. Apperson had a duty to retreat if he was engaged in criminal activity. And the relevant part of the instruction stated, and this has happened twice. First, if Matthew Apperson was not otherwise engaged in criminal activity and was in a place he had a right to be, then he had no duty to retreat and had the right to stand his ground. And second, however, the defendant had no duty to retreat if he was not otherwise engaged in criminal activity and was in a place where he had a right to be. The problem with this instruction is that for all 3 of the charged offenses, Mr. Apperson raised self-defense, and all 3 offenses were based on the same act of him firing a gun at a vehicle driven by George Zimmerman in this case. There was no other charged offenses for which he did not claim self-defense, and there was no other evidence he was engaged in any other criminal activity other than the charged offenses. So we have circular reasoning from these instructions that effectively negated his sole defense to the charged offenses.
Your position is that, not that that instruction is generally incorrect, but that it was inapplicable in this case? Is that correct?
Correct, Your Honor.
And did the state make any arguments to the jury about a duty to retreat?
They did, Your Honor, and that exacerbated the prejudice to Mr. Apperson. At page 814 of the trial transcript, the prosecutor said, quote, "No duty to retreat." Mr. LaFay made that argument, well, he is wrong because there are exceptions to the stand your ground law. And quote, "The second exception is if you yourself are committing a crime and then you claim self-defense, you have a duty to retreat." So that suggested to the jury that when Mr. LaFay, the defense lawyer, argued that Mr. Apperson did not have a duty to retreat, that he actually did because he was engaged in criminal activity. And again, there was no offenses other than the offenses Mr. Apperson argued he was acting in self-defense for, and no evidence he was engaged in any independent criminal activity in this case. So the state argues in their briefs that the closing argument was not improper because the prosecutor was just explaining the general law on stand your ground. But this isn't a law school class where we're just talking about the general law. The prosecutor's arguing the facts of the case and asking for a conviction. So he's directly arguing that Mr. LaFay was wrong to say that Mr. Apperson did not have a duty to retreat because he was engaged in the commission of a crime. That's improper under the case law, Martinez, and more specifically the Novak case from the 4th DCA, which we believe is right on point. And this closing argument exacerbated the prejudice and establishes that there's ineffective assistance on its face. We have both deficient performance and prejudice to Mr. Apperson because he was deprived of his sole defense. The Novak case had a very similar instruction, and the 4th DCA in 2008 says, defendant also argues that the jury instruction imposing a duty to retreat on a defendant who employs self-defense while engaged in unlawful activity was confusing under the circumstances because the defendant was not engaged in any unlawful activity other than the crimes for which he asserted the justification. Same situation here. All three offenses, Mr. Apperson argued self-defense, testified on his own behalf, and said he was acting in self-defense for all three charged offenses. And the 4th DCA says, defendant's argument is well taken as a logical application of our holding in Giles. And they said,
Did either of those cases include a jury instruction on no duty to retreat, as there was in this case? The general instruction on no duty to retreat when?
The Novak instruction, Your Honor, was, quote, if the defendant was not engaged in an unlawful activity and was attacked in any place he had a right to be, he had no duty to retreat. So it's our contention that there's no material distinction between the instruction in Mr. Apperson's case and the instruction found in Novak.
Except in Novak, didn't the otherwise was not included within the instruction, correct? Not otherwise engaged in unlawful activity?
That's correct, Your Honor. It's our position that the otherwise is not sufficient to clearly indicate that it had to be separate criminal activity. This is a jury of non-lawyers, of laymen. They're not wordsmiths. More importantly, there was no reason for that instruction to be included at all. That sentence or that portion of the sentence should not have been included at all. There was no reasons to reference criminal activity. It's confusing, misleading, and I think almost identical to the instruction in the Novak case. The better instruction would again be to admit the part about criminal activity, or to say no duty to retreat if he was not engaged in criminal activity aside from the three charged offenses. That would have been more appropriate, but I think the easiest thing is just to delete that portion of the instruction, of the two instructions in this case, because they simply didn't apply. There's no evidence of other criminal activity and no charged offenses to which Mr. Apperson did not claim self-defense.
You agree that this is an invited error?
And that's why it's argued as ineffective assistance of trial counsel, which I believe is apparent on its face. This court in Morgan rejected a fundamental error argument based on the invited error doctrine, but then found ineffective on its face because the trial attorney invited the error in the instructions. So yes, it's invited error, and that's why it's not raised as fundamental error. It's raised as ineffective on its face because there's no good reason for a trial lawyer to propose an instruction that negates his client's own defense, sole defense in this case. And the Spicer case from this court indicates that it's ineffective on its face to object or suggest an instruction on self-defense that makes it easier for the state to get a conviction, and that's what happened here. So based on Morgan and Spicer, we have ineffective assistance that's apparent from the record, that can be dealt with on direct appeal, and this court should reverse based solely on that. But we have additional errors in this case. The self-defense instruction deviated from the standard instruction. The last paragraph admitted the words beyond a reasonable doubt. The state concedes that was an error, but argues that it's harmless or not fundamental because there's a subsequent instruction on reasonable doubt. The problem with that argument is that the subsequent instruction only addresses reasonable doubt as it addresses the elements of the offense, not the affirmative defense of self-defense. So that does not cure the error. We have the last paragraph on page 418 of the record. If from the evidence you are convinced that Matthew Apperson was not justified in the use of deadly force, You should find him guilty if all the elements of the charge have been proved. The standard instruction, 3.6F, says, if from the evidence you are convinced, quote, beyond a reasonable doubt. The 3 words beyond a reasonable doubt are omitted from the instruction. There's no justification for that. Standard instructions are presumed correct. This court has said in the Curry case, we can think of little more fundamental in a criminal trial than instructing the jury on the state's burden of proof beyond a reasonable doubt. The law is clear that the state has a burden to prove that the defendant was not acting in self-defense beyond a reasonable doubt. That's also found in the Spicer case. So that omission is important. It's relevant to what the jury has to consider. The jury certainly notices the words reasonable doubt in one section and notices it missing in another section where it's supposed to be. They're told that the law that they're given is what they're instructed on, both in writing and orally from the judge. So there's no justification for that omission. Next, it's our position that the trial court abused its discretion by allowing the prosecutor to misstate that Mr. Apperson had a duty to retreat because he was engaged in criminal activity, as I discussed previously. And again, that's on page 814 of the record here in the trial transcript. It's misleading, it's confusing, because there was no evidence that Mr. Apperson was engaged in criminal activity other than what he was charged for, and he raised self-defense as to all 3 offenses. Finally, the trial court abused its discretion by denying the motion for mistrial when the prosecutor argued that Mr. Apperson's acts put passerbys, pedestrians, and people riding bicycles in danger. The charged offense is against Mr. Zimmerman, not against passerbys. You can't appeal to the community conscience or cite danger to the community when the offense is charged against Mr. Zimmerman. The Smith court, the Smith decision from this court says, such arguments distract the jurors from the duty to reach a fair and just verdict based solely on the facts and evidence presented at trial. And the courts have repeatedly condemned impassioned arguments which appeal to the jury's community sensibilities or civil conscience. There's no basis for this argument. The case law is clear. The trial judge should have granted a mistrial, and we'd ask the court reverse on that, or based on a combination of the errors, reverse Mr. Apperson's convictions, and I'll reserve the rest of my time for rebuttal.
Thank you. You have about 3.5 minutes left.
Good morning, Your Honors. May it please the court, counsel, Andrea Totten on behalf of the state of Florida. Your Honors, first I want to point out something that was alluded to during opposing counsel's presentation. The errors that we're talking about here were not preserved. These jury instructions were not only not objected to, but provided by defense counsel. And therefore, the invited error doctrine does apply here. I want to quote from
Does it apply to an argument of ineffective assistance of counsel?
Your Honor, I believe that that is the general rule, that it would apply. There have been exceptions, as was alluded to. For example, this court in Spicer underwent such an analysis. The defense counsel there provided a jury instruction that said that the defendant had to prove self-defense beyond a reasonable doubt, and then repeatedly argued that improper standard to the jury in closing arguments. And this court recognized that normally that would be invited error, but because of the particular facts of that case, it was nonetheless ineffective assistance of counsel on the face of the record. But that was in a very extreme case. Again, the defense counsel repeatedly argued the wrong burden of proof to the jury. This court characterized this burden shifting as a breakdown in the adversary process sufficient to undermine our confidence in the outcome of this trial. We certainly do not meet that standard here. The real question in this case, and the essence of Mr. Apperson's defense, was Mr. Zimmerman pointed a gun at me, and therefore I was justified in shooting him. The prosecutor never argued that Mr. Apperson could not avail himself of a self-defense defense based on the fact that he was committing criminal activity. That was not argued. The one reference made by the prosecutor to that issue in closing argument came simply in response to defense counsel repeatedly suggesting that there's never a duty to retreat. The prosecutor briefly clarified, well, sometimes there is a duty to retreat under this circumstance and that circumstance. That was the entirety of it. The prosecutor never pursued a theory that the defendant was engaged in criminal activity and therefore had a duty to retreat. That wasn't the state's theory of the case.
Can you think of any strategic reason why counsel would agree or submit this flawed instruction?
Your Honor, I haven't been able to come up with a scenario that specifically addresses that, but it's far from devastating. I can understand why a defense counsel would not think it's important to redact that language. You could easily make a strong closing argument that says, look, my client does not have a duty to retreat here. The only way he had a duty to retreat is if he was engaged in criminal activity and no one's asserting that he was, or engaged in a forcible felony of some sort. No one's asserting that he was. It's basically harmless, especially in a case like this where that was not the crux of this case. How can something that's not important to the case at all result in fundamental error, even after applying the invited error doctrine and trying to make an argument that's normally procedurally barred for ineffective assistance of counsel?
So do you agree that the instruction was erroneous in this circumstance?
Your Honor, I do not agree that the error was erroneous in this circumstance. I do recognize that Novak case exists. I would note that Novak was decided in 2008, and I cannot find a case that cites Novak for the principle that it's cited for here today. And frankly, I think Novak is simply incorrect in its reasoning on that point. The criminal activity language, as was previously alluded to, includes the language otherwise engaged in criminal activity. That's really different than the Martinez problem, where the 776.041 first says, defendant can't use this defense if he was engaged in a forcible felony. It doesn't give any explanation about other than the ones that he's charged with, and that led to the problem in Martinez and other cases where the jury was told, if you find that the defendant committed the crimes that he's charged with, then he can't possibly have been acting in self-defense. There's that circular logic.
So is it your argument that counsel's performance here, at least as it relates to the jury instruction, wasn't deficient?
Your Honor, I would argue that it was not deficient, especially when you apply the deference of Strickland to say, we have defined not only that defense counsel made some error, there's always going to be some error in a trial. The defendant's entitled to a fair trial, not a perfect trial. Counsel has to have been acting so deficiently that the defendant was not provided with counsel under the meaning of the Sixth Amendment, totally out of step with professional norms. That's the standard that we have to meet here to show that defense counsel was deficient.
Well, but isn't the real question for us whether or not the instruction as it was given essentially eviscerated the sole defense in the case? I mean, at the end of the day, isn't that what we have to decide? And that's really, we have to apply the smell test to it.
I agree with that analysis, Your Honor. And here, again, because the state was not arguing that the defendant was not entitled to act in self-defense because he was engaged in criminal activity, it's not fundamental error. It didn't deprive him of his sole defense. I would refer the court to Garrett, a case that I supplemented with.
You agree it was his sole defense. The question is, did the flawed instruction deprive him of that defense?
Correct, Your Honor. His defense was self-defense, but his theory of self-defense was Mr. Zimmerman pointed a gun at me, so I shot at him.
Right. I mean, at the end of the day, the question is who pulled the gun first?
That's exactly right, Your Honor. Again, the criminal activity thing was just not the focus of this case. It was, did the jury believe or not believe the defendant's version that Mr. Zimmerman had pointed a gun at him? Or even if they did happen to believe the defendant's version, which seems unlikely given that 3 officers testified that the tint on Mr. Zimmerman's windows was so dark that you could not see through it, despite defendant's testimony that he could see through the glass, unlike the 3 officers who testified and saw this gun. Even if the jury were to agree with defendant that Mr. Zimmerman pointed a gun at him, then they would have to go to the initial aggressor instruction that was given and evaluate, well, even if we believe this, was Mr. Apperson justified in shooting at that point? Was he or was he not the initial aggressor? And look at it from that point of view. But those are the issues in the trial. Did Mr. Zimmerman point a gun at him or not? And because the jury was still charged with finding, was there an imminent threat? Was Mr. Apperson under such a threat at that moment that he was justified in shooting? That's what they were charged with deciding. That they got a proper instruction on that, and the criminal activity is just irrelevant to their decision-making and thus not fundamental error. I want to note the omitted beyond a reasonable doubt instruction. First, as noted previously, the very next instruction given to the jury was the general beyond a reasonable doubt instruction. The immediately preceding instruction was that if the jury had a reasonable doubt about whether the defendant acted in self-defense, it should find him not guilty. Defense counsel repeatedly argued without any objection to the jury that the state must prove beyond a reasonable doubt that defendant did not act in self-defense. The prosecutor, and I'll cite you to pages 804 and 805 of the trial record, twice told the jury that the state had to prove beyond a reasonable doubt that the defendant was not acting in self-defense. Under these circumstances, there's no reasonable possibility that the jury had any misgivings or misunderstanding regarding what the burden of proof is. That was the theme of defense counsel's closing argument. The state must prove beyond a reasonable doubt that my client was not acting in self-defense, and the state agreed to that and adopted that standard in its own closing and overcame it. With regard to the closing arguments, I do want to note, first of all, that as I argued in my brief, these arguments, with the exception of one, were not preserved for appellate review. So I would assert that they have to be reviewed only for fundamental error. The first one, the allegation that the prosecutor was mischaracterizing the law. First, that's simply not correct. There are circumstances under which a defendant has a duty to retreat. The prosecutor properly explained those 2 circumstances, one being the unless otherwise engaged in criminal activity, the other being the initial aggressor under 776.041. That was a proper recitation of the law as it existed at the time. However, when you read those comments in the context of the argument before and after, it was clearly in response to defense counsel's repeated allegations that there's no duty to retreat, implying that there's never ever this duty. The prosecutor simply saying to the jury, look, there are circumstances when there's a duty to retreat. At that point, there's an objection. The court never sustains or overrules the objection. Defense counsel does not press for a ruling on the objection. The court merely says, jury, I'll explain the law to you at the end of the case, and the argument proceeds on, with the prosecutor, again, never arguing that criminal activity aspect of the instruction, and no further objection. The other one that was mentioned was the danger to other individuals argument. That argument was preserved. The defense counsel objected and moved for a mistrial that was denied. I would remind the court that motions for mistrial are reviewed for abuse of discretion. The court gave a curative instruction to the jury that said, please disregard the prosecutor's last comment about depraved mind. So the defense got the relief it sought. The objection was sustained. The court instructed the jury to disregard those last comments, and closing arguments continued on. Given the surrounding facts and circumstances, there's no reason to think that this passing comment, an argument by the prosecutor that was immediately cured by the court, vitiated the trial such that reversible error occurred. So the state would contend that defendant is entitled to no relief on those grounds either. Your Honors, if you have no further questions, I will rely on my brief.
And counsel.
Thank you.
May it please the court. The state argues that Novak is wrongly decided, and the problem with that argument is it was the only case on point at the time of the trial, and Mr. Apperson's trial counsel had a duty to be aware of it and to apply it and not submit an instruction that negates his sole defense. The Fourth DCA says a reasonably effective criminal defense attorney must keep himself or herself informed of significant developments in criminal law. The Novak case and the Martinez case from the Florida Supreme Court were both decided prior to this trial. Trial counsel had a duty to be aware of them and to not submit an instruction that negated his client's sole defense. Secondly, the state's argument that the state never argued that he had a duty to, that Mr. Apperson had a duty to retreat because he was engaged in criminal activity is just not supported by the record. Again, page 814 of the transcripts. It's not a law school class. It's not a general explanation of self-defense law. The prosecutor argues Mr. LaFay argued he had no duty to retreat and he is wrong, and then cited the portion of the instruction that says, if you yourself are committing a crime, you have a duty to retreat. There's no other way to construe that as to say that the state is arguing Mr. Apperson had a duty to retreat because he was committing a crime, because he's not charged with any offense for which he was not claiming self-defense, and there's no evidence he was committing any other offense. Finally, the state's argument that it's harmless based on the facts of the case ignores the fact that this is simply a credibility contest between Mr. Zimmerman and Mr. Apperson. The problem with the circular instruction is the jury could believe everything Mr. Apperson said, but because they think he was engaged in the conduct that was alleged as a charged offense, find him guilty and find his self-defense was negated. So that's not harmless. It's circular for the reasons stated in Martinez, for the reasons stated in Novak, for the reasons stated in Giles. And finally, we're arguing ineffective assistance to counsel on its face. This court has rejected the invited error said in Morgan that invited error does not preclude that. And in the Sloss case from this court, we're arguing ineffective on its face, not fundamental error. In the Sloss case from this court in 2010, this court had initially found no fundamental error in a forcible felony instruction, but subsequently found ineffective assistance of counsel. So that's the more relevant standard, the Sloss case, the Spicer case, and the Morgan case. And for those reasons, the trial lawyer's conduct in providing that instruction to the trial court was both deficient and prejudiced Mr. Apperson, and he's entitled to a new trial on all three counts. So I'd ask that you reverse. Thank you.
And counsel.